My name is Dr. Doug Ruben, and I'd like to share with you a case study. The case study is titled, Should You Believe the IME? Today's prolific use of forensic psychologists in criminal court often involves the common role of an independent medical examiner, or IMEs. Now, an IME is a hired consultant or an examiner requested to render a second opinion on different types of discovered evidence, assisting the prosecution or the defense in the adjudicative process. IMEs are especially valuable in criminal cases, where the defendant's plea is incompetent to stand trial. Under such pleas, defendants probably will first transfer from county jails to a state forensic facility. There, they undergo intense scrutiny of multiple psychological evaluations. This helps to guide the court on, first, whether they are competent to stand trial, second, whether they are not competent to stand trial, or third, are they trainable to learn competence to stand trial. No doubt, states will vary on the differentiation of competency status. Sometimes, decisions about competence are not cut and dry. I'd like to share with you a case of an adult, psychotic, symptomatic defendant who was arrested for attempted murder. And there was evidence from 4 psychological evaluations conducted over a 2-year period of time at the same state forensic facility. These showed the same results, that he was incompetent to stand trial. Now, naturally, one would expect that if a 5th psychological evaluation from the same facility might yield similar results. But it didn't. The 5th psychological evaluation showed the defendant was competent to stand trial. Now, this outcome, under most circumstances, would confuse any defense team or attorney. Enter the IME. I was hired to perform an independent psychological evaluation of the defendant to determine 2 factors. First, was the defendant competent to stand trial? And second, why did the outcome of the 5th psychological evaluation at the forensic facility differ so radically from its 4 predecessors? On the surface, a simple reading of the 5th evaluation clearly explained this reason. See, the defendant, now on psychotropic medications, can control his positive psychotic symptoms and, not surprisingly, met criteria for competence to stand trial. Well, past use of psychotropic medications apparently failed to manage his psychotic symptoms and made him volatile in court. But after altering the medications, the defendant apparently met the first 4 of 5 fundamental criteria for adjudicative competence. These include: first, he could understand the process of the trial and the role of the judge, jury, prosecutor, and defense attorney. 2, he could establish a working relationship with his attorney. Third, he had sufficient intelligence and judgment to listen to the advice of counsel, and based on that advice, appreciate, but not necessarily adopt, the fact that one course of action may be more beneficial than another. And fourth, he could appear competent to decide how to plead a charge. However, even on the medications, he did not meet the final criteria for competence. This new cocktail of medication helped, but it didn't guarantee it. And the 5th one is that he would appear sufficiently stable to withstand the stress of a trial without suffering prolonged or permanent breakdown. The preparation for the IME began. Police reports, interviews with family, past testimony in court documents, and the careful reading of the past psychological evaluations all indisputably pointed to the same conclusion: the defendant's unpredictable, psychotic-like behaviors, delusions, hallucinations, and erratic, angry outbursts disqualified him for competence to stand trial. In other words, I concurred with what the first 4 psychologists said. So why did the 5th psychological report say the defendant was competent to stand trial? I wondered that myself. Here was a couple of points to consider. First, the evaluator of that 5th psychological evaluation based conclusions on one brief interview period, half the time spent by other examiners, and did not perform any clinical, forensic, or structured interview or repeat psychological testing. Second, that evaluator relied heavily on medical reports or improved socialization of the defendant while the medicated differently. Third, a court order for the judge compelled the submission of updated quarterly progress reports showing how the defendant was improving. He didn't want to disappoint the judge. This means submitted reports needed to reflect positive behavior changes and especially approximations to or achievement of competence to stand trial. And fourth, the defendant supposedly took his revised cocktail of medications in the afternoon around when this brief window of an interview occurred. In all prior forensic facility evaluations, medications routinely were administered in the morning, and the evaluations occurred in the afternoon. Well, let's begin my examination. I met the defendant over 2 consecutive days in the county jail at methodically scheduled and limited time periods of 3 hours interval each. This was to prevent concentration decay, fatigue, and any risk of his anger escalation. Scheduled evaluation days deliberately matched previous testing time periods. One evaluation day occurred in the morning, and a second evaluation day occurred in the afternoon. This approach covered optimal periods of psychotropic effects on the defendant in case his medication scheduled varied unpredictably, like if it was in the morning or in the afternoon. The defendant underwent a structured forensic interview designed for malingering and competency detection, for example, the ECST revised or the SIRS, and a standard psychological battery. The battery consisted of selected projective, intelligence, and objective personality tests like the TAT, MMPI-2, WAIS-4, so forth, all completed visibly in front of me while I sat across from the defendant. During the interview, his fragmented thinking, circumstantiality, and tangentiality varied, with periods of lucidity. For brief moments, he was coherent, rational, could answer questions articulately, and even show impressive insight. As briefly as his cognitive set was coherent, he regressed to delusional paranoid statements, gibberish, and complained of auditory hallucinations. Not surprisingly, my findings concurred with the first 4 psychological evaluations reported by the state forensic facility. The defendant did not meet the criteria to competently stand trial. In my report, more than other previous psychological reports on the defendant, caveats, or warnings, clearly caution against the risk of courtroom volatility and dangerousness toward nearby parties like the judge, the attorneys, etc. These results derive from compelling test scores in both observed and reported incidents of the defendant's rapid cycling of unpredictable hostile moods associated with violent outbursts. Despite the obvious parallel with findings from the first 4 psychological evaluations and my warnings issued about courtroom danger, the judge upheld the 5th forensic opinion. This opinion asserted that the defendant was competent to stand trial. The court did not believe the IME. 3 weeks later, I learned from the defendant's attorney what happened on the first day of trial since my evaluation. No sooner did the defendant arrive in the courtroom and sit adjacent to his attorney when the judge read aloud the docket number and gave opening remarks. At that instant, the defendant flew out of his chair and in a furious rage darted toward the judge. He was subdued immediately by the bailiff and attorneys and removed from the courtroom in shackles.